afternoon, everyone. Thanks for joining CBIA's HR Hotline live webinar. I'm Diane Mokriski, an employment attorney here at CBIA, and I'm joined by attorneys Nick Zaino and Vincent Farisello from Carmody Torrance Sandak Hennessey. Nick and Vincent are both partners at the firm, and they both focus their practice on employment issues and advising employers on best practices for how to comply with employment laws. So today our focus will be on absenteeism in the workplace, whether that's due to a serious medical condition or just the common cold or poor performance. And as I mentioned, this is a hotline webinar, so that means that we won't be presenting prepared materials, but instead we'll answer your questions as they come in live. This is your opportunity to ask how to handle absenteeism issues as they're coming up at your workplace. So please submit your questions through the Q&A, and we'll get to as many of them as we can in the next hour. So we're going to dive right in. We have a lot of people connected, and I think we're going to have a lot of questions to answer. So first of all, Nick and Vincent, welcome.
Thank you. Thank you.
So I'm going to start with a question I get a lot, and then I'll turn to the questions that come in. This is kind of our kickoff. This is such a common question. I know that you guys have gotten this a lot. So when an employer is considering disciplining an employee for absenteeism issues, let's say the employer has gotten to the point where they've just said, I've had enough, I just want to fire the guy. Is there a list? Is there some sort of checklist that you can give that employer should kind of go through before they make a termination decision?
Yeah, I think that is a question we get a lot, and it's a really good one. But I think the first place to start is knowing why the person has been absent. It's really important to know the reason behind it, because that's necessary to determine if the leave is protected by law or perhaps permitted by your policy or some benefit that you provide. And if it is protected by law, then generally an employer really can't discipline for a protected leave, a protected absence. If it's not protected by law, on the other hand, the question is really whether that absence is permitted by the employer's policy or under an employer-provided benefit. And secondary to that, whether the employee complied with the related requirements, things such as notification procedures, et cetera. So once you know the reason for the absence or continued absences, knowing that reason is number one on the checklist. From there, the checklist moves to trying to determine whether that absence falls under any protected category. And there's a veritable alphabet soup of different protections out there, from FMLA to ADA, CFEPA. But just to do a little bit of level setting, a little bit of, the legal landscape, a grounding for those out there. Start with FMLA, Family Medical Leave Act. There's two of them, a federal and a state one. And that does provide both of them provide job protected leave for certain absences that are covered by the law. There's also pregnancy accommodation statutes, both federal and state, that allow an employee to be off from work for disabilities related to pregnancy. There's perhaps workers' compensation issues. Now, remember, workers' comp, what it really does is it provides a system for compensation and rehabilitation for folks who suffered injuries or illness in the workplace. Doesn't provide a leave per se, but workers' comp does prohibit discriminating against someone who is using workers' comp benefits. For those non-manufacturers out there and those who have over 50 employees, Connecticut has a paid sick leave law that protects at least up to 40 hours per year for an employee's or their family member's illness. And then there's also the potential for leave of absence due to an employee's disability under the ADA or similar state law, the CFEPA. So those are kind of the major job protections. There's also things in Connecticut too, like protection for absences due to family violence or domestic violence or military leave. So You got to start, number one, figure out what the reason is. Number two, does that reason fall under one of these job protected categories? And if not, you then check the next part of the checklist is looking at your policies and your benefit program. Look at your PTO policies. Is this absence covered by that? Did they abide by the call-in procedures, the attendance rules? Does it qualify perhaps for short-term or long-term disability? And so that's what I see as the checklist in looking at these, evaluating whether to discipline for absences. And back to the original question again, if that leave is protected by law, likely can't discipline. If not, maybe you can, but go then run through your policies, see if they're abiding by the the provisions and the terms of those policies. But also, I would also say, don't lose the forest for the trees, though. Not every absence in and of itself should immediately spark thoughts of discipline. Consider the context, consider the employment history, consider the circumstances. Is this part of a pattern? Is this more of an isolated incident? Is this, more in the category of I lost my keys, I'm continuing to have car trouble, I'm oversleeping, I had a late night last night. Those are things that aren't protected and generally aren't going to be accounted for in a policy. So, as you consider these things, just again, don't lose the forest for the trees and consider this in the context of the person involved and the issues involved.
All right, so Nick, if we first focus on the things that are not protected, so we can kind of get rid of those first. Let's say hypothetically, well, like Vincent said, you've got this chronic issue with someone saying, I forgot my keys and my car broke down. And it's just this over and over, these issues that have nothing to do with medical things. What are some things, what are disciplinary things that an employer can do? What are their choices?
Yeah, so those things that are not protected, the employer can take progressive discipline is what we generally would recommend. So you should have, as employers, an attendance policy that underscores the importance of employees having reliable and dependable attendance and being to work on time. And if somebody is not, for reasons that are not protected, you should follow your normal progressive discipline. So it may start with a warning and then go from there. And obviously, the hallmark of any discrimination claim is consistency. So you want to treat absences in a consistent manner. Some employers have very detailed policies, Diane, where they literally do a point system for absences, and then at certain number of points or tardinesses, they have a very specific process for discipline. Other employers, it's done a little more, just a little more generally with some discretion. So, but those absences are subject to disciplinary action by the employer.
What about docking the employee's pay? Can you have a policy where you just say, hey, anybody who's late, that's like a $25 fine or something like that? Or if you're failed to show up, is a fine of some kind.
Yeah, no, that would not be, we would not advise that you do that. I don't think that would be permissible under state law. Rarely do you want to mess with somebody's wages to address a performance issue. If it's a performance issue, address it through your progressive discipline performance process, warnings, performance improvement plans, suspensions, whatever it might be, counseling, but don't use pay or don't dock pay as a form of punishment. I think that's just going to land you with wage and hour issues.
Yeah. Yes. So I believe there are a couple of statutes that specifically address that and that the Labor Department really takes seriously. So I know CBIA has done various webinars or seminars in the past about the scenarios when you can take deductions from someone's paycheck, and they're rare. So yeah, as you said, other forms of discipline, the warnings, the progressive discipline is the way to go.
Definitely.
So if we move, all right, so let's say we've addressed the situation where the absence is not protected for some reason. That's the employer's discretion. Yes, you can discipline them. However, you discipline other things. So let's move on to things that are protected. So you've got an employee who's calling in sick a lot. How do you know if it's covered by FMLA? Are you supposed to ask them personal questions about their illnesses?
So what I would say first is you should have an FMLA policy that's in your handbook that notifies employees that you comply with the Connecticut Family Medical Leave Act, assuming you're covered, which I'm willing to bet most of the folks on this call are. That defines, at least in general terms, what constitutes a serious health condition, all those things that you're required to have in a policy. So through that handbook, employees are on notice of what your policy is and what you will do for family and medical leaves. At some point, however, and I know there's a question in the Q&A that kind of touches on this a little bit. The standard under the FMLA is if you have reason to know that it might be a covered reason under the Family and Medical Leave Act, you have to offer that. So you can't insist on sort of a rigid process that somebody must formally make a request for FMLA. If the employee through their call outs, right? So if somebody's calling in and just saying, not feeling well today, can't make it, or have a sore throat, and there's just a variety of different reasons that none of which give you or put you on notice that it might be a serious health condition, then I think you just treat them as absences that aren't covered under the FMLA. But if they're calling you and you know they have an issue with migraine headaches, and they keep calling in and saying, I'm having another issue with a migraine headache today, not able to make it, or leaving work saying, I have a migraine headache, that is enough to put you on notice that that might be a serious health condition. So it actually depends a little bit on what the employee is saying when they leave a message. If they're being really vague and they're calling out a lot due to sickness, it probably makes sense to ask at that point, look, you've called out quite a bit. It's beyond what we allow for sick leave. Is there something going on that we need to be aware of? And then make an assessment of what the reasons are and whether it qualifies for FMLA. But I don't think you can just say, well, they didn't use the words FMLA, therefore it's not FMLA.
I think another piece too, just to piggyback on Nick's comments, is keeping in mind what the definition of serious health condition is under the FMLA laws. And so there are certain things that should, kind of get an employer's antenna up. If you hear someone's going to be, having an inpatient stay at a hospital or other healthcare facility, that likely qualifies as a serious health condition. If they're going to be needing continuing treatment by a healthcare provider, and along with that, they're going to be incapacitated for 3 or more days, needing medical treatment. And you don't necessarily need to know at that point exactly what their issue is, but if you have enough information to know that this is going to be 3 or more days, and it seems to be related to the same thing, that should be enough to have you start that conversation. And you can do it in a pretty neutral way too. Nick, you kind of alluded to it, but you don't need to start with a question of what it is that they're suffering from. It could be how much, this is how long you've been out. Do you anticipate needing more? Because we need to determine whether or not something like FMLA is implicated.
Yeah, and so in the chat, you can see there's a link to, it says, here's some additional information from the state of Connecticut related to the FMLA. So that portal site will take you to FMLA forms. So if you are an employer and you are wondering, you think maybe your employee might have something that's covered by FMLA, you can give them these forms. It doesn't mean necessarily that they qualify, but what you're basically telling them is that they've met the minimum standard so that if they do have a serious medical condition, they qualify. So you give them the form, and then it's really for the employee and the physician or the healthcare provider to give you the information you need to make that decision. Does that sound fair, Vincent and Nick?
Yes.
Yes, absolutely.
That website is actually pretty useful. Not only does it have all the forms on there that you need throughout the FMLA process, but it also gives you kind of some general information on FMLA as a whole. So what I take from that, one thing that Vincent said, if all the employers out there could familiarize themselves with the term serious health condition, that's a legally defined term. That's probably also at that same link. You need to have a serious health condition to be covered by FMLA. And that's like the $1 million question. And so that's for their healthcare provider to figure out and tell you, this is what's going on, this is how much time they need, and you can kind of take it from there. All right. Let's move on to workers' compensation. So if someone's out on workers' comp, how long are we required to keep the employee's benefits active before we terminate and offer COBRA? Would like to,
Yeah,
I'm
so
gonna
this,
pick on this because
yeah,
we talked about this.
so this is gonna aggravate some people, I think, but, so there is an insurance statute, and Diana and I are chuckling because we asked for some guidance from the Department of Insurance on this statute, but the insurance statute in Connecticut basically says that insurers, it puts the obligation on insurers and sort of indirectly on employers, that you must continue coverage for employees and their covered dependents during employees' absence due to illness or injury for up to 12 months. So I guess what I would say is if somebody is out on workers' comp and they're on a leave of absence because of workers' comp, if you're covered under the FMLA, you definitely have to do it, but you have to do it under this Connecticut statute if you are insured. If you're self-insured, this Connecticut statute does not apply to you. And so if you're a fully insured plan, I would say double check with your insurance carrier as to whether or not there's language in your plan. I bet there is if they're complying that says you have to continue coverage for up to 12 months. So, which I would probably advise you anyway. Like, I don't think I would mess with somebody's health insurance when they're on a workers' comp leave. I'd rather you address the employment status as to whether or not you can continue to accommodate that workers' comp leave, which probably brings up another question, which is how long do you have to hold somebody who's on workers' comp leave? But I'd rather you make an employment decision and not say you can remain on leave of absence, but I'm not covering your insurance unless you're self-insured and you're not subject to this Connecticut insurance statute. Otherwise, I think you have to hold it.
Yeah, so, and I mean, I think a lot of people, when they see that those words 12 months, they think, oh my God, 12 months, but that doesn't mean that you have to keep their health insurance going for 12 months. It just means if they're still employed with you for that whole time, you're keeping their insurance going for that 12 months. You could let them go sooner than 12 months though, even though they're on workers' comp. So do you guys want to address that? When can you finally pull the plug if someone's on workers' comp? Can you actually terminate someone?
So it's, unfortunately, there isn't, you're not going to find a bright line rule out there for that. There's no statute or regulation that says after you fill in the blank number of months or years, you're able to do it, without any questions asked. It's really kind of following a similar analysis and process as you would under general, both FMLA and ADA/CFEPA standards. And what I mean by that is a lot of times a workers' comp absence leave is going to be covered by FMLA. So just a good reminder, if someone is eligible for FMLA, it can run concurrently with their workers' comp leave. So if it does, to the extent that they run concurrently, it's going to be protected under FMLA for up to 12 weeks. After that, as would be the case with any medical issue, workers' comp or not, you may have extinguished your obligation as an employer after 12 weeks to provide job protected leave under FMLA. The question then turns to, okay, but if the employee is requesting some additional leave, is that a request for a reason for an accommodation under ADA? Is it reasonable? And can the employer provide it without causing undue hardship on the employer? And that's always going to be a really fact-specific inquiry based on the industry, the employer, the number of employees, the type of role. To what extent can we continue to operate without causing an undue hardship with this person on a continued unpaid leave? And so I think that same analysis is what controls when you're dealing with someone who has been out for an extended period on workers' compensation, who's collecting workers' compensation benefits. So it's going to really come down to whether or not, to what extent you can continue to accommodate that person's absence. Now, that also doesn't mean you have to hold someone's job open indefinitely or forever. But to say, oh, at such and such date, at such and such month marker, you can do it easily, isn't really an accurate thing to say.
And to answer a question about that health insurance issue, yes, while the employee is out and you're continuing their insurance, the employee continues to pay their portion. And so and that may, if they're not earning enough through their benefits or whatever, then they send in a check and you arrange with them for them to send in their portion of their premium. Yeah, so I mean, that's the answer to that question. One question came up, Vincent, you mentioned something about for FMLA that triggers when someone's been absent for 3 or more days. And I think that's that's the most common way.
Yeah.
There was a question, does it have to be 3 days? And it doesn't, the answer to that is no. There are other ways that you can get FMLA leave. And if CBIA people are able to get this on the chat during this webinar, that would be great. If not, we can send it out later, but the regulations are available. It's the Connecticut FMLA regulations. They're going to be 31-51 QQ. So we're going to give our CBIA people some time, see if they can come up with that. But so the regulations will really define all these words. And Vincent, do you have that handy?
I could summarize it really quickly. Like I said, FMLA, an employee could be eligible or qualify for FMLA. Number one, if they require inpatient care as a result of their illness or injury. Number two is if they require continuing treatment by a healthcare provider, including one of the following. Number one, this is the 3-day rule. If they're with the continuing treatment, they also will be incapacitated for 3 or more days, plus receiving medical treatment. That's number one. Number two, if they will be incapacitated due to pregnancy or prenatal care, no 3-day qualifier there. If they have conditions that require multiple treatments, think things like cancer or things that will require physical therapy, no 3-day qualifier on that. Or 4, if they are going to, if they have a chronic medical condition, something like, epilepsy or asthma or something that can flare up on occasion, also no 3-day qualifier there. The 3-day qualifier really comes up in a non-pregnancy situation where there's incapacity due to a medical issue.
Yeah, so one scenario that might come up, which I've gotten questions on, that would be covered by FMLA would be mental health issues. So you don't have to be completely incapacitated for 3 days, but if you have, if the employee gives you documentation from their healthcare provider that says that they've got a chronic serious health condition that's going to require periodic visits, that's potentially something that would be covered under FMLA. So that's something to keep in mind. We've had a lot of questions about mental health recently, which is indicative of the world today, I guess.
A few things just to close the loop on it.
Yeah.
Some things that generally, not in all cases, but generally don't qualify as serious health condition. Your common flu, run-of-the-mill, common cold, run-of-the-mill flu, stomach bug, routine dental care. One that, we get some questions on here and there is about COVID. Does COVID qualify as a serious health condition? A lot of, in a lot of cases, it doesn't. Even with the 3-day incapacity rule, because most run-of-the-mill cases don't really require medical treatment. But if you have a case of long COVID or severe or moderate illness that does require hospital care or does become chronic in nature, it could be in those circumstances. But your standard everyday run-of-the-mill sick for a few days and then fine generally won't qualify as a serious health condition. But folks are free to apply. And I know that the CT FMLI authority has certainly gotten many of those applications and been thoughtful about denying or approving.
Okay. All right. So when we, Nick, when you were talking about how you cannot fine anyone or take money away from someone as a punishment for attendance issues, are employers legally able to deduct a percentage of someone's year-end bonus if they have
Yeah.
attendance?
Yeah, so red flags go off all over the place for me on that question. It sort of depends on your bonus program. If the bonus program, and I believe if I'm going off recollection, if your bonus program is specifically intended to provide a bonus for perfect attendance or for attendance, I think the federal FMLA allows it, but Connecticut does not. But I'm assuming that's not really the intent of this bonus program. The intent is probably a mixture of production and performance. And so I would not single out attendance. So in other words, a much better bonus program would say, you're eligible for a bonus based on, your productivity and your overall performance, taking into account not just attendance, but any progressive discipline, any warnings, any bad reviews, anything like that. I think if you just simply say, you're entitled to a bonus of X, but we get to adjust it based on your attendance, it sounds like you're going after, in all likelihood, in most cases, it'll be a medical leave. So I would be very wary of that and want to just know a little more information about that.
Okay. Vincent, how about a COVID question? And it really has to do with just what the tenor is at work. So people have been used to more flexible policies during COVID, being like, we understand you have COVID, of course you're absent. But now, is there a good way to get back to basics? And this person says, we've toyed with the idea of having a building-wide stand down and addressing a change, but we have concern over being too abrupt or being seen as inconsistent.
I think the key here is communication, whether it be in a, a building-wide town hall style thing, or even a communication, or maybe it's, if there's some concern about being abrupt, maybe it's a multi-pronged approach where there's an initial written communication that's followed later by a town hall style meeting. But I'm all for that because even here at our firm, we've had to do some level setting. Lots of clients we talk to have had to do some of that level setting and trying to get back to a state of normal. So I'm less concerned about the being seen as inconsistent. Yes, of course, we always want to be consistent, but if we're being open and honest and communicative about trying to get back to a pre-COVID way of running our attendance policy, I'm all for it. And I think that the communication is the key.
Okay. This is a really common question, almost on a daily basis. What should an employer do if the FMLA paperwork doesn't get returned, if the employee just doesn't give it to them?
So we generally, what I generally do is write a letter. I encourage the employer to try to communicate with the employee saying, look, we gave you the medical certification form on X date, that provided 15 days. The 15 days is expired. Can you please return it as soon as possible? Some kind of letter to the employee. And the employee, maybe they come back and they say, yes, I'll get it to you. My doctor, I tried, and they couldn't do it for whatever reason. So I don't like the idea of denying FMLA on just a technicality, even though the person may have a medical condition. They just didn't get it back to you within that 15-day period, because there are sometimes circumstances beyond their control, and they may very well have a legitimate medical issue. So I wouldn't stand on that basis alone, but there definitely are those circumstances where the employer has tried and has tried and has tried and has tried, and the employee simply will not return the paperwork. And in that case, you are free to assume that it's not a covered family and medical leave reason. They haven't provided any information to support that it's a serious health condition or that there's a disability under the ADA or Connecticut law or any other job protected statute, assuming it's not workers' comp. So in that case, the absence is not protected. And I try to make that clear, or suggest to employers that they make that clear in the communication before they actually take the underlying action, the disciplinary action for attendance issues. So make it clear when you're saying, we need that in order for it to qualify as FMLA and therefore be job protected. If you don't provide that, the absence is not protected and is subject to discipline. Usually that should get employees to act. And if it doesn't, and you've tried and they won't, then go ahead and act on that discipline that's reasonable based on the level of absence.
Mm-hmm. So that was in response to the anonymous and also Marianne, you. So if Marianne, that didn't answer your question, why don't you send in a follow-up? And so Vincent and Nick, can you look at the question from Diane? I was thinking about asking for follow-up information, but if either of you know what she means, do you know how to answer that?
Is that in the Q&A?
It's in the Q&A. It says, can we ask for a doctor's note if someone is in progressive discipline for absences? And the absences aren't FMLA related. Even if they say it's the issue they have FMLA for.
No, I think the question is asking if someone, I think Diane is saying that you have an employee who has an approved FMLA leave. And it sounds like in this case, it would likely be on an intermittent type basis. And there's someone who separately is in the progressive discipline process because of unrelated, non-FMLA related absences that may have occurred beforehand. And so now they're calling in and saying, as saying it's for their approved FMLA. The general rule for intermittent FMLA is that you can't ask for a doctor's note every single time someone utilizes their approved intermittent FMLA. If, for example, it's for flare-ups or for doctor's appointments. But this is where that medical certification form that you got back is very important, and so is the designation notice. If those absences that they are now citing to be covered by the FMLA are not consistent with what was provided in the MedCert form, then that will give you some opportunity to then ask for further documentation or recertification. So it's important, those forms, it's not just it's a good lesson to not just, go through the motions with these forms. When you get a MedCert form, actually really try to understand it, scrutinize it, make sure the designation notice, what you provide is consistent with that. And then you can hold folks' feet to the proverbial fire by asking simply how it relates to or how it's covered by their approved intermittent FMLA circumstance.
All right, thank you for that. That does make sense. Okay, how about caregiver leave? The question is, does federal or state FMLA protect absences when taking care of a loved one? For example, an employee misses 2 days a week because they need care of their mother who has in-home care and the in-home care doesn't show up.
Yeah, I think the short answer is yes. I do think Connecticut FMLA, federal FMLA allow an employee to use FMLA for the serious health condition of a covered family member. And so assuming that person at home has a serious health condition, there's a medical certification form, and that medical certification form says when the caregiver doesn't show up, your employee is required to be there to provide care, comfort, and assist that family member, then I think that would constitute leave under the Family and Medical Leave Act, intermittent leave in that case.
Yeah. And so do you think that employers have an obligation, particularly, let's say in this scenario, to point out to the employee, you can probably get paid benefits for this too. Is it up to the employer to tell employees that, to go apply for that?
Yeah, I think I think it is. I think that is part of the notice requirement under the revised Connecticut Family and Medical Leave Act, that you have to include that in the policy, and probably fine to do that too. Like there's probably no downside to doing that. Like I don't like when there's a disconnect actually between the job protected FMLA leave and a person being eligible for FMLA leave or paid FMLA from the FMLI, because employees tend to think they have two sets of job protected leave. So I'd rather they sync up, but I do think you have a notice obligation, at least under your policy. I don't know that you have to say it affirmatively again, but I would probably do that. I would probably suggest that an employer let the employee know that they can go ahead and apply for FMLI benefits as well.
Okay. How about one from Karen? How long does an employer need to cover employees' health benefits, including long-term disability, if if they're out on FMLA and not paying their premiums, knowing they're in rehab. Okay, does anyone want to handle that? So, I mean, if the person's in rehab, that's so tricky. I mean, you know why they're not paying, right? And I guess we're not talking about health insurance. In this one, we're talking about other benefits like short-term and long-term disability.
Yeah, so again, this is one of these where I think, so if we're not talking about health insurance, because under health insurance, federal FMLA, at least 12 months, and then under this Connecticut insurance statute, if you're fully insured, 12 weeks, I should say, under federal FMLA, the Connecticut insurance statute, if you're insured 12 months, up to 12 months while they're employed, if it's for their own serious health condition. And if you're talking other benefits, again, I would suggest a letter to the employee warning them, making it very clear, send it certified mail that they haven't paid. And if they don't continue to pay, they're going to lose that benefit. Like, make it clear, give them a reasonable grace period to pay. But at the end of the day, they have an obligation to pay their share of any health benefits, including LTD or health insurance for that matter. And I would just want to know that there's a good paper record that you tried to get them to pay. You explained the consequences of not doing so, and they just simply failed to pay their share.
I think on the health insurance piece, under the federal FMLA, there's some pretty specific timelines there for if you're dealing with a situation of non-payment.
Right.
There's a 30-day grace period following the agreed upon due date for the premium. And then following the 30-day grace period, an obligation to provide another 15-day final. You have to give a final warning with a 15-day additional period for them to remit payment. That's again under the federal FMLA rules. But if like in the circumstances we saw here, if someone's either incapacitated, there's a good reason why they're not being responsive, I would tread very, very carefully. As opposed to someone who's just who's available, but just, ducking their obligation.
Right.
Practically speaking, it may also help if the HR person maybe contacts a emergency contact, like a family member, just to give them a heads up. Hey, we're trying to reach your husband. It's really important. Could you have him check his email or see if they have authorization to check his email? Just so it's clear that you really did try to let this person know that benefits are going to be lost.
I agree.
We're still talking about health insurance. Let's go to Cheryl. What if the employee doesn't pay their portion while out? Does the employer still have to provide? Okay, we kind of covered that. Vincent mentioned that there's a grace period of 30 days, and we're going to try to contact them. And eventually, if they don't pay, non-payment is reason enough to cancel benefits. How about this? Is there a list that employers can use for serious health conditions that are approved? Who wants to tackle that?
Yeah, I think the best thing you're going to get is kind of looking at those regulations that you mentioned before, and even the federal regulations, which the citation is escaping me now, but that does give some really good examples of things that fall in those various categories, like those ones that I mentioned before, like, chronic medical conditions. I think I got some of those examples from the regs, a chronic medical condition being epilepsy or asthma, for example, or a condition requiring multiple treatments, clearly cancer, or, someone who may have had a broken limb that requires some ongoing physical therapy. That's where you're going to get the best examples. I don't think you're going to get a list of, hey, these are all the things that count. These are all the different types of conditions that qualify for each specific category of serious health condition.
Yeah, I mean, it'll depend, right? Because sometimes a broken leg might be enough. Sometimes it maybe won't. It kind of depends what the doctor says, what the patient's going to need, right? So unfortunately, unless, like Vincent said, there are some very specific examples in the regulations, like I think it mentions Alzheimer's and a stroke. You know, there are certain things that are really pretty clear that they're serious enough that it's going to be covered. But other than that, it'd probably be best to not have a guaranteed list. Like if you have one of these, like migraines are huge. That's huge. Migraines are so difficult to administer FMLA for because it's almost always intermittent. And it might be at the last minute, like, oh, I have a migraine, gotta go home, right? But there'll be some people with migraines whose physician might say, yeah, no, they're not actually that serious for this particular person. Right?
This overall question is a really great example of why the MedCert form is such a useful and important tool, because no matter what condition someone has, it still needs to check the boxes of incapacity for 3 or more days, or requiring multiple treatments, or being chronic in it. Either way, some medical professional is going to have to fill out that form in a way that's satisfactory, that shows satisfactorily that it qualifies as a serious health condition, regardless of what it is. So that's really how you make the determination.
All right, let's go to the Lux Bond in green. We've tried very hard to communicate with employees about applying for Connecticut paid FMLA. Some have opted not to do it because it takes so long. I have one person still waiting from January 11th. An employer can't communicate with AFLAC on behalf of the employees. We would like to help our employees with paperwork, but our hands are tied. I have an answer to that, but I'll go to you guys first. Do you have any thoughts on how to give employers, oh, no, okay. Why don't you answer this? Is there any thought to give employers online access to see the status of our employees' claims? I didn't realize it was going to end with that. Do you know how Aaron Choquette often answers that question?
Yeah, I don't know if there's any plans to be allowing employers right now to access the status of an employee's claim, but I do know anecdotally that, the authority was sensitive to and responsive to some early criticism about communication with the employer. And my understanding, and it seems to me that the authority through AFLAC has been more communicative and sharing some information. I'm not sure about any online access, but if there's feedback like that from employers, I'm sure the authority would welcome hearing some of that feedback in a constructive way, whether it be in writing or electronically, or going to some of their ongoing educate. I know they still are doing educational workshops. I'm sure some of the concern is about protection of health information, but it's, perhaps there's a way to do it in a way that protects that, or it's not necessary to divulge, but it's purely speculative. And I think it's important to just provide feedback to the authority.
Yeah, I know that the paid leave authority has gotten this question a lot, and I don't know of any current plan to give employers access online. However, once your employee has applied and has a case number, I have had some members have success contacting the paid leave authority and giving the case number. And sometimes you can get in contact, like for example, CBIA had a special FMLA group, like a pilot program where employers had specific representatives at the paid leave authority that they were allowed to contact. I think that pilot program has ended now, but I mention that because there are certain people at the paid leave authority who are designated to answer employer questions. And so if you go online, you can see there's a way to ask a question. And so you could go to their website and say, I have a claim number. Is there anyone I can talk to about the status of this claim? And I think that would be a good way to at least establish contact with someone at the paid leave authority. I think they would at least contact you and tell you what your rights are. I don't know that they would give you specific medical information, but they might be able to give you kind of an update on the claim itself, on how long it might be. So that was January 11th, and now we're in February. That actually kind of surprises me. I thought they were a little bit, I thought the backlog was not that long.
Yeah, I've been hearing that it's, most of the feedback I've gotten from clients is that it's going much quicker.
Yeah.
Not instantaneous at all, but quicker than it was a year ago.
Yeah, so mental illnesses we covered quickly. Mental illness is often covered under FMLA. Same standard, right? Do you guys, I mean, it's still got to be a serious health condition. It can just be a mental serious health condition. Is there anything else in particular that you guys think to be aware of when it comes to mental illness FMLA claims?
Not really. I think the approach is the same as it is for a physical illness. Same analysis. If the individual gives you enough notice that they have a mental health condition that might qualify as a serious health condition, you'd follow the same path as you would a physical condition. There's no distinction.
Okay, let's talk about FMLA and workers' comp a little bit more, just to clarify. I think we talked about that, and I just lost it. Okay, if FMLA runs concurrently with workers' comp, as it almost always does, I keep losing it because more questions come in. Assuming they have health insurance and we keep them on the plan, when they return, can we still collect their portion of the premium, or is it different because they were out on workers' comp?
No, you could still collect. I mean, you have the right as an employer to require an employee who is on a medical leave for whatever reason to still pay their share of the employee premiums. In other words, they don't get treated better than an employee who's working for you who's not on an FMLA or workers' comp or any other medical leave. They just can't be treated worse. So you can't treat them worse than you would an employee, an active employee or an employee who's not on FMLA. You can't retaliate against them, treat them worse because they took a medical leave. So, but you can still require that they pay their share. And if the arrangement is you do it when they get back, that's okay too.
Mm-hmm. All right, so I'm going to the question that came in at 141. We touched on this a little bit, but the second part of the question has to do with, so they don't return the paperwork, right? It's an FMLA issue and they don't return the paperwork. Can we discipline them for that? And also, if they elect to not apply for paid leave, can we decide to not pay them if they have PTO remaining? So do the discipline one first for not turning in their paperwork.
Yeah, so assuming you've gone through that process, right? You've given them multiple opportunities to get you the paperwork, and for no good reason, they simply refuse to do so, or they just fail to do so, then yes, the answer is that absence is not, you can't designate it as FMLA, and there's nothing to indicate that it's for a medical reason. You have the right to get a doctor's note, even if they don't return a medical certification. Let's assume you're trying to figure out if it's something that might fall under the ADA or Connecticut Fair Employment Practices Act, and they just refuse to cooperate. Then that leave is not authorized, or it's not an approved medical leave, and they're subject to discipline. Again, just make sure you jump through the proper hoops. On the second question, if they elect to not apply for Connecticut paid leave, can we decide to not pay them if they have PTO remaining? And so that kind of gets into, there's a little bit of coordination of benefits there, but remember, you're not designated as a FMLA leave. And so it just becomes a question of what your PTO policy says. Does it fall within the PTO policy that they get paid for some piece of it? And if the answer is yes, then yes, under your policy. But you're not designating it as FMLA, so there's not really whether they get paid leave benefits or not doesn't seem to factor into that analysis.
If you did get to a point where they're not qualified for FMLA or any other leave, they're also not applying to the state for it, and they're just going to be out for some period of time, but they have PTO, you should think about, does it make sense to let them be out unpaid just while they continue to have PTO in their back pocket to be able to use if and when they do come back to work? It may behoove the employer. And, this might be different for different employers out there. There might be different philosophies, but it might behoove you to have them draw down on the PTO while they're on this absence.
Yeah, and that's actually a question I get a lot, which is, we have these employees who, it's not FMLA. We have these employees who are absent, but they don't want to use their PTO. They just want it to be an unpaid absence, but can we make them use their PTO? And so I think, Vincent, you were saying, yeah, if that's what you want your policy to be, it makes sense to have them use their PTO.
Yeah, absolutely. I get this question all the time.
All right, so we've got a question about, this is a theoretical question, but we'll see what you guys think. This is from Heiss Industries. So there's a bit of a inconsistency, I guess, with how COVID is not necessarily a serious health condition, but if you have it, you have to stay home. So how do you rectify that?
Well, I don't know that there's, I could be wrong. I don't think there's anything out there that like an actual legally enforceable obligation that says thou must stay home from work if you have COVID. Obviously, we all want people to do that because we don't want to be spreading it. But, so for most cases, fortunately, a lot of cases, it does wind up being more similar to the flu or the common cold. And as we've dealt with those things historically, that have not risen to that. It's purely a matter, again, of that definition of serious health condition. And if it is a run-of-the-mill minor case of the virus, it doesn't meet that definition. And we nevertheless want them to stay home for purposes of not spreading it. But we also should want people who have the flu or a really bad sinus infection to stay home too, so they're not spreading that to others. Or the stomach bug. It's certainly not fun if an office or a workplace has that going around.
Mm-hmm.
Yeah, if somebody says, you're never going to believe this, but this is my 4th incident of COVID this year, right? We're going to play the theoretical thing here. Like that's 4 times 5 days, that's 20 absences, right? None of which are serious health conditions. Can you discipline an employee for being absent 20 times for illnesses that are none of which rise to the level of a serious health condition or the ADA? So you might be able to. Obviously, you're not going to do that. I don't think employers are going to do that for just one instance of COVID. You want the employee to obviously stay home and not be subject to discipline. But if it happens over and over and over and over again, and this person seems to always get COVID, and it's now 20 times, maybe you're going to say, look, that's a problem for us. And you may have very valid legal grounds to do that.
It kind of does dovetail to the question, though, of like using your fact pattern. All right, you've had it 3-4 times. Now, can you say, I need to see the positive test now? I want to see the test.
Yeah. Oh, they give it to you. What if they give it to you? I mean, we're playing games now. I don't want to get
right,
hypotheticals that don't occur. But yeah, let's assume it's legit. Like they did it 5 times or 4 times. Still 20 absences, right?
Yep. So the answer to that is yes. If someone's been out 20 times, I mean, you have a sick leave policy, right? You're allowed to have a sick leave policy. And if it's 5 days, 20 is way more than 5.
Exactly.
And so then you're just having to decide, well, that's up to the employer. There's no legal answer to that, right? Like, yes, you could let them go. That's too many absences.
Right.
Or, if you would prefer to be more lax on it because they have COVID, that's fine too.
Right.
Okay, let's go to the one at 145. We have an employee who has developed a condition with pain in legs and feet, not job related, that's limiting his productivity and ability to do his job to the point where we may have to dismiss him. Is this employee eligible for job protected leave and or paid leave? What do you guys think?
I mean, that is one where I think you have to have a conversation with the employee about the condition. That could very well be something that's covered in the Family Medical Leave Act, a condition that that doesn't allow them to work, pain in both legs. And, even though it's not job related, the FMLA covers both job related and non-job related serious health conditions. And so that feels like it might be covered under the Connecticut Family Medical Leave Act, or at a minimum requires a conversation with that employee, and maybe you give them the forms and have your doctor fill it out. So on that condition, I'm assuming is a medical condition, not just not something that's non-medical. So
Yeah. Yeah, I mean, I guess we're assuming that this, yeah, it limits his ability to do his job. I mean, he may also have a disability that you'd have this obligation to have that conversation that you
Right.
mentioned and figure out, is there an accommodation? You tell us, you're saying to the employee, you tell me, what accommodation could we give you that'll still let you do your job? And if he can't come up with one, then that's different. But you got to look into FMLA and the ADA first. Don't go right to dismissal.
correct.
Okay, we have something nice to say about the Connecticut paid FMLA. That's nice. Once the paperwork and documents were submitted, everything went quickly, so that's good. Thank you for telling us that. Let's go to the one at 152. If an exempt, you guys have to refresh your memories on these exempt and non-exempt rules. If an exempt employee exhausts vacation and sick time, can a company dock his pay?
So there are very specific rules about that, but one of them is that if your vacation sick leave policy is very clear that you can do that, and it is for the employee's sickness or illness, they've exhausted it, and it's 1 or more full days, and your policy has been clear that it could be docked in that way. My understanding was that yes, you can.
Yep,
Oh, I
Nick?
agree. Yeah, no, I agree. I agree. There are specific reasons, as long as it's not a partial day absence, it's a full day absence, then yes, I think that's one of the reasons you can deduct from an exempt employee's pay. You don't get unlimited vacation, unlimited time off if you're an exempt employee.
Right. And so are either of you gentlemen prepared to answer a use reg question?
I saw that one.
It's just a little involved. I'm sorry, anonymous. That's why I didn't get to it. Vincent, are you?
Yeah, so here, while we were going through the other questions, I was trying to look at that specific reg that was referenced there.
Yep.
And what it's, I think if someone is being very clear, upfront, honest, I'm not coming back, I am resigning, I think it is okay to process that resignation and end their employment. What I think the regulation is trying to say, though, is if within the requisite time periods they finish their service and do want to come back, that doesn't necessarily mean that they don't have any reemployment rights, which seems very counterintuitive. And so anonymous is wise to kind of pick up on that, on that seeming inconsistency there. But I just think that what the USERRA reg is trying to do is protect someone who may be perhaps under duress, or may have circumstances change, or may be pressured into making a decision early on about what their intent will be at some point later when they do finish their service.
Okay, thank you. And if you, anonymous, you have further questions about that, because that involved a very specific reg that requires us to read that. That was a little involved, but you can, at the beginning of this chat, there are email addresses for Nick and Vincent and I, so you can follow up with any of us on that. Going back to one at 119, I'm not sure if Marianne means short-term disability, or do you guys know if after FMLA leave exhausts and the employer is self-insured, so we're not talking about the 12-month rule, is the employer required to offer COBRA?
You're not required, not required to offer COBRA. Right? I mean, after FMLA exhausts and the employee is self-insured, is the employer required to offer COBRA? I mean, I think it depends on your plan. Like, you can't keep somebody on your health insurance plan indefinitely, right? So I don't think your health insurance plan says after FMLA ends, you must offer COBRA and remove that person from the FMLA or from health insurance. But that doesn't mean you can't have that as a policy, assuming you do it across the board for all medical leaves, whether it's FMLA or non-FMLA. And, So I don't think it's required unless for some reason it's in your plan that says you must. It's not legally required. You can, again, if you do that consistently. I don't think most employers do that, however. So
Whereas if let's say FMLA leave exhausts, and then as a result of that, employment is terminated, then you would offer COBRA.
Oh, of course. Yes. Yes. And remember, this is just for a self-insured employer. So for those of you who are fully insured, this wouldn't, what I just said wouldn't apply to you.
Do you guys have 5 more minutes? If I can come up with, we'll go a little bit late.
Sure. Yep.
Let me just see if I can do, okay. Let's do the one at 159. If employees are scheduled to work 9 hours a day, but get charged 8 hours per full day FMLA absence, can you charge an employee half an hour? Oh my gosh, that's very specific. Okay, I'm gonna have to, unless you guys want to answer that, I think I'm gonna ask that person to email me. Is that okay with you? That's a little, that one was a little confusing. We've got frustrated people at Heiss Industries. Oh, okay, I'll address that regarding the COVID. That's what Heiss Industries is talking about. Okay, so when you have COVID, the CDC recommends that you isolate if you have COVID. That is not a legal requirement, as Vincent said. That is a health-related public health issue, that if you have COVID, they would like you to isolate and not spread it to others. That's separate from employment laws, which dictate when an employer, when a company has to pay people, even though they're absent. And so right now that all those federal programs have expired, employers are no longer required to pay their employees, even though they have COVID. And so you have a sick leave policy for that. So if your employees have COVID, just like if they had the flu, they stay home. We prefer that CDC would say, we prefer that they stay home. Theoretically, they could not tell anyone they have COVID and still come to work, but that would stink for everybody because then COVID would keep spreading. So the CDC says we prefer that you stay home, but employers, don't worry, you don't necessarily have to pay for that. We'll leave it up to you to come up with your sick leave policy. Okay, that's kind of my re-summarize of what
Yep, you said it well.
saying. All right, so we have gone over. If you are a CBIA member and you still have a question that wasn't addressed, you can email me. And you can always call or email Nick and Vincent. And let me just make sure. Yep, at the beginning of the chat, we've got contact information for them. So thank you, Nick and Vincent, for your help. As always, we do this quarterly, these hotlines. So tune in again. And just so everyone knows, CBIA has an HR conference on March 21st. So we hope you join us for that as well. And until next time, thanks very much, guys. And thanks everyone for attending.
Thanks, everyone. Thanks, Diane.
Bye.
Bye-bye.